Thank you for joining us tonight, and welcome to the Northwest Consumer Law Center webinar series, How to Survive the Financial Impacts of COVID-19. Today's webinar is Bankruptcy and COVID-19, Should I File and Other Considerations During a Financial Crisis? My name is Amanda Martin, and I'm the Executive Director of the Northwest Consumer Law Center. If you have questions during the presentation, please enter those in the chat box on your right. This session is being recorded and will be available on our website by tomorrow afternoon. Attending this webinar does not create an attorney-client relationship. This presentation provides legal information and is not a substitute for individualized legal advice. If you're seeking legal assistance, we recommend that you contact the Northwest Consumer Law Center after this session. Information on how to apply for our services will be posted at the end of this webinar. And with that, we'll start with the presentation. So talking today, we will be going over bankruptcy basics. What is a discharge? Chapter 7 versus Chapter 13. The automatic stay. We'll talk about considerations for filing during a financial crisis. What's going on at the bankruptcy court right now, and resources for debtors. First, talking about what is bankruptcy. Bankruptcy is a process that allows individuals and businesses to get out from under debt. Bankruptcy is here to provide people with a financial fresh start. Generally, bankruptcies fall in two types of categories: liquidation and reorganization. A person who files for bankruptcy is called the debtor in the case. And there are two types of bankruptcies that most consumers choose between: Chapter 7, which is a liquidation, and Chapter 13, which is a reorganization. We'll be talking about the differences and a brief overview of each of these chapters later in the presentation. The goal in most bankruptcies is to receive a discharge. A discharge gets rid of your financial and personal liability for dischargeable debt. Generally, dischargeable debt is credit cards, medical bills, personal loans. Car loans and mortgages are dischargeable in bankruptcy. However, if you want to keep the car or keep the house associated with that car loan or with that mortgage, you need to continue paying on those loans. Generally not discharged in bankruptcy are student loans, domestic support obligations, criminal fines and restitution, personal injury claims related to intoxicated driving. Some taxes are not dischargeable in bankruptcy. If you're wondering about whether a certain debt is discharged or isn't discharged in bankruptcy, you should talk with an experienced bankruptcy attorney. Next, we're going to talk about Chapter 7 versus Chapter 13. Chapter 7 is our liquidation bankruptcy. That makes it sound a lot scarier than it actually is. The purpose of bankruptcy, again, is to get a fresh start. And in order to have a fresh start, you're going to need certain things, like a reasonable car to get to and from work, money in your bank account to pay your rent, household goods, clothing. There are exemptions, laws that allow people to protect certain interests in property when they file for bankruptcy. The goal of a Chapter 7 is to get a discharge. A Chapter 7 typically lasts 3 or 4 months. If there's property to be liquidated in the Chapter 7, it can last for longer than that because the trustee is selling those non-exempt assets. You can only receive a Chapter 7 discharge every 8 years. There's no hardship discharge in a Chapter 7. It's from the date of filing. You have to wait 8 years. You also have to pass what's called the means test. The means test looks at whether you're under your state median income for your household size. If you're under that, you can file a Chapter 7 without a presumption of abuse. A Chapter 13 bankruptcy is a repayment plan. The goal is to repay certain debts, such as a mortgage arrearage. If you're behind on your mortgage, you can create a Chapter 13 plan where you're paying your ongoing mortgage payment and catching up on what you're behind. You can also pay traffic tickets through a Chapter 13. Again, like a mortgage, if you're behind on your car payments, you can pay that in a Chapter 13. You can also pay non-dischargeable IRS debts in the Chapter 13. One of the requirements that comes with Chapter 13 is that you have to commit your disposable income to the plan. So when you take your net monthly income and subtract your normal expenses like food, utilities, whatever is left over has to be committed to the plan. A Chapter 13 plan can be anywhere between 3 and 5 years, depending on what your income is. One of the benefits of bankruptcy is the automatic stay. The automatic stay is a pause button. It prevents creditors from attempting to collect from you. The automatic stay is very broad. It applies to collection calls, letters, and other communications from creditors. It applies to a continued garnishment. It applies to foreclosure sales. It applies to repossession of a vehicle. It's a very powerful tool in the bankruptcy. The automatic stay does not go into effect until the case is filed. And the automatic stay can be limited in certain cases. If you have one or more prior bankruptcies in the past year, that automatic stay can either not go into effect or be limited to only 30 days. There is a way to extend the automatic stay by filing a motion. There are many exceptions to the automatic stay, and I definitely recommend speaking with an experienced bankruptcy attorney if you have any questions about whether the automatic stay will go into effect in your case or if it'll apply to a certain action. What it does not apply to is criminal proceedings. It does not apply to most family law proceedings. It does apply to division of assets in a dissolution. Timing the bankruptcy filing, you don't want to be too late. You need to know the deadlines to stop a foreclosure. The automatic stay goes into effect when the case is filed. So if we have a foreclosure sale scheduled for Friday at 10 a.m., if we file that bankruptcy Friday at 9 a.m., the automatic stay is in effect. You also need to know the deadlines for stopping an eviction. For the means test, this is looking at your income for the past 6 months, and for stopping a judgment from being entered. It also may pay to wait to file a bankruptcy to remove the taint of certain bad acts, certain luxury items that were purchased within a period before bankruptcy. You might want to wait 6 to 12 months. Also, it gives you time to settle non-dischargeable debts. And so some debts are old enough to be discharged. So in some cases, taxes can be discharged in the bankruptcy, depending on the age and what kind of tax they are. So it's very important to consider the timing of when you file. Considerations for filing during a financial crisis. There are many factors that go into deciding whether to file bankruptcy. And what we're about to talk about is not an exhaustive list. You should seek legal advice from an experienced bankruptcy attorney before filing. What I always tell clients first is let's think about what options are available to you besides filing for bankruptcy. Debt negotiation, settlement, or consolidation is an option in some situations. There are a lot of scams out there for debt negotiation, settlement, consolidation. You should definitely do your research, get recommendations before you sign any type of agreement or pay anyone money for debt negotiation or consolidation. If you're looking to file a bankruptcy to stop a foreclosure or to catch up on your mortgage, I definitely recommend that you check out loss mitigation options like a loan modification or a refinance, something that allows you to catch up on your mortgage without the bankruptcy. I also get a lot of calls from people who want to file bankruptcy because their creditors are calling them nonstop. The Fair Debt Collection Practices Act is what regulates debt collectors. In many situations, when we start talking about why clients want to file and because they're getting these harassing calls, they might actually have Fair Debt Collection Practices Act claims against these debt collectors. We also have situations where people are what are called collection proof. This means they don't have any assets or any income that can be taken to pay back their creditors. An example of the situation is somebody whose only source of income is Social Security. They don't own a house. That person would be considered collection proof. And even if their creditors sued them to collect on the debt, there's no way for them to force them to repay it because their Social Security is protected from garnishment. Other considerations for filing include whether you have an urgent legal situation, like an impending foreclosure, garnishment, or repossession. If somebody's in a situation where there's a week until their foreclosure sale and they don't have a time to apply for loss mitigation, bankruptcy could be an option for them. You also need to think about how long your financial hardship is expected to last. People sometimes jump the gun after perhaps getting laid off or having reduced hours and want to file bankruptcy right away. I always caution those people to think about what the next few months are going to look like for them and whether they're going to have additional debt that they have to incur, such as medical bills that they don't have insurance for. So people need to think about how long they expect that financial hardship to last and whether they want to file now or perhaps wait until things play out more in the future. Another consideration, if you're filing a Chapter 7, is will you be able to keep all of your property if you filed for bankruptcy? It's very important that before you file, you talk with the bankruptcy attorney, review your exemptions, and make sure that all of your property is protected if you file Chapter 7. And again, if you choose to file for bankruptcy, what's the ideal time for you to file? Does it make sense to wait? Or does it make sense to file now, perhaps to stop an ongoing garnishment or an impending foreclosure? The Western District of Washington Bankruptcy Court is still open. The public courthouses are closed to the public right now. The bankruptcy clerk's office is not providing face-to-face services. They are available by phone or by their online chat. There are drop boxes in the lobby of the courthouses where people can drop off documents to be filed. And you can also mail in documents or payments to the clerk's office. The United States trustee has made arrangements for 341 meetings. This is the court date that most debtors have to attend in a Chapter 7 or a Chapter 13 bankruptcy. These are being done telephonically. And most hearings are taking place telephonically during this time. So if somebody is in a bankruptcy or about to file a bankruptcy, there's a good chance that your hearing dates are going to be over the phone. I encourage people to continue to check the bankruptcy court's website to see about the changes in the situation. Again, this is a rapidly evolving situation, and they're changing things as they go along. Resources for people who are thinking about filing for bankruptcy. The Northwest Consumer Law Center has the Pro Se Bankruptcy Clinic. This is held on the first and third Thursday of each month from 2 p.m. to 4 p.m. Normally, this clinic is held at our bankruptcy court in Seattle, but we are holding it by phone right now. So if you are interested in setting up an appointment, you can call our intake line at 206-805-1722. This is only for people who are under 200% of the federal poverty level, and it's a brief advice clinic. But debtors can attend the clinic as many times as they need to get brief advice. We also recommend that you go on the Western District of Washington Bankruptcy Court website, which is available here. Many resources are available under filing without an attorney, including the court forms that you can download. And now I'll open it for questions. If you have questions, please enter those in the chat box on your right. And I had a question from somebody who missed the first 2 minutes. The PowerPoint will not be shared later, but this session is being recorded and will be made available on our website by tomorrow afternoon. We have another question from somebody asking whether student loans are discharged in bankruptcy. Student loans are not automatically discharged in bankruptcy. If you're seeking a discharge in the Ninth Circuit, where Washington is located, you have to prove that you have an undue hardship. An undue hardship is a difficult test to pass under our current case law. It requires that you maintain a minimal style of living and that you prove that you cannot repay your student loans over a long-term plan. It's a pretty in-depth analysis to see whether people qualify for an undue hardship discharge, and I recommend that if people are interested in that, they talk to an attorney. And for options for student loans, you can also see our webinar that happened on Wednesday that's available on our website. We have one more question. Somebody asking whether filing for bankruptcy will save their home from foreclosure. For a Chapter 7 bankruptcy, if you are in foreclosure, filing for bankruptcy in most situations will pause the foreclosure. It will give you some time to look at other options for saving your house, but ultimately a Chapter 7 is not the end-all be-all solution for saving a home. Usually you need to get a loan modification or a refinance. For a Chapter 13, in many situations, you can propose a plan where you're paying your ongoing mortgage and catching up on what you're behind for the Chapter 13, which will allow you to get caught up on your mortgage and stop the foreclosure. All right. Please see our website to watch the recordings of the other sessions in the Northwest Consumer Law Center webinar series, How to Survive the Financial Impacts of COVID-19. Sessions on rent, mortgages, student loans, and consumer debt are currently available on our website, and the recording of this webinar will be available by tomorrow afternoon. If you're seeking legal assistance, you are welcome to contact the Northwest Consumer Law Center to apply for help. We are able to help those of low and moderate incomes in Washington State. You can apply online on our website, nwclc.org/get-help, or by phone at 206-805-1722. If you have questions after this webinar, you're welcome to contact us by email at admin@nwclc.org. To support our work, you can make a contribution online by going to our website. Thank you everyone for joining us today, and take care.